Hey, everybody. It is Brian Foley. I'm with Houston Criminal Defense Attorneys. And today we're going over a very long and tedious statute. It is the self defense law in the state of Texas. A few things up front. Basically, we're going to be reading through the statute and I'm going to slow it down at some points, kind of explain what's going on. And let's just get into it. So, uh, self defense 9.31 of the Texas Penal Code. Subsection A says, except as provided in subsection B, which is times where the use of force is not justified, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. So, who is the actor? That means not like Tom Cruise or somebody like that. The actor is the person who's being charged with a crime, because you're not going to be talking about self defense in this statute unless you've already been charged by the district attorney's office, likely with some kind of crime. This is not deadly force. We're going to get to deadly force. That's 9.32. This is just regular force. Do you believe that force against another, when and to the degree the actor reasonably believes that force is immediately necessary? That's when you're justified. Immediately necessary is a term that's been interpreted. Reasonably believes is a term that's been interpreted. And it basically amounts to, would somebody in your situation think that you had to act and use that force? Otherwise, the other person is going to be using unlawful force against you. Okay. So the actor's belief that the force was immediately necessary, as described by this section, is presumed to be reasonable if the actor knew or had reason to believe that the person against whom the force was used either, and then there's three categories here, was unlawfully and with force entered or was attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business or employment. So it means the state of Texas presumes that you got it right and you were acting in self defense if that person was trying to get into your house, was trying to get into your car, something like that. If they were trying to do any of those things, then you're going to be presumed to be reasonable in your use of force. Subsection B for that is unlawfully and with force removed, or was attempting to remove unlawfully with force the actor, the defendant, right, from the actor's habitation, vehicle, or place of business. So if they're trying to kidnap you, take you, drag you out of your home, you can use force. It's assumed to be presumed by the jury to be uh, lawful for you to use that and that you were justified. It can be presumed if this person, this other person, was committing or attempting to commit an aggravated kidnapping, murder, sex assault, sex assault, robbery, or aggravated robbery. And you did not provoke the person against whom the force was used. So you can't like call somebody up on the phone and say, "You're an asshole, come to my house, I'm going to fight you." And then they come to your house to fight you and then say, "Oh, I'm using self defense." You can't provoke the other person. Uh, and you can say the person was not otherwise engaged in criminal activity other than a Class C misdemeanor that's a violation of law or ordinance regulating traffic at the time the force was used. So that means if you're in violation of some other law, let's say you're driving while intoxicated, or you've committed criminal trespass, or you're unlawfully in possession of a firearm by a felon or something like that, and then you also are attempting to use this physical force and self-defense, then you can't use self-defense. You have to not otherwise be engaged in criminal activity. Okay, so now let's look at subsection B, the use of force against another not being justified. Okay, it is not justified in response to verbal provocation alone, right in the statute there. Words enough are not going to be enough. Now, if somebody says, "I'm going to come stab you," and they're holding a knife, that's not words alone, right? That's the action of holding a knife. Maybe they're fairly close to you, but it's not enough if they just say, "You're an asshole, I'm going to kick your ass." They have to like start coming towards you or something like that, because in response to verbal provocation alone, not justified. It is not justified to use force to resist an arrest or search that the actor knows is being made by a peace officer or by a person acting in the peace officer's presence and at his direction, even though the arrest or search is unlawful, unless the resistance is justified under subsection C. We'll take a look at that in a minute. But in general, do not resist, use force against the police, even if they're acting unlawfully. We fight that in court later on, not out there on the street. Subsection 3 here under B. So this is B3. If the actor consented to the exact force used or attempted by the other, this would be like if you have agreed to a boxing match. It's not self-defense. You're not justified, but it may not be an offense otherwise, but the actor consented to the exact force used or attempted by the other. And then 4, if the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons that encounter and clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and the other nevertheless continues or attempts to use unlawful force against the actor. Okay, that's a long one. So if you provoked the response, if you're the one who said, "I'm going to come kick your ass," and you walk towards that person, okay, that's kind of a threat. Now, if you then see that it's Bruce Lee or Chuck Norris that you have threatened, and you say, "Hey, I'm abandoning this encounter," I suppose would be the best words to use. That's what the statute says. But if you say, "Hey, man, I give up," and you run away, uh, you would have to then say that maybe you're falling under here that the actor has clearly abandoned your encounter, your aggressive behavior towards Bruce Lee or Chuck Norris. You clearly communicated your intent to abandon this. And then Chuck Norris or Bruce Lee continues to try to beat you up for your attempt there or your threat to do so. Well, then that would be unlawful for Bruce Lee. You may be justified, and it's not an assault on you anymore. If the actor sought an explanation, and so here's another example. We're now on subsection 5. The use of force against another is not justified. Subsection 5. If the actor sought an explanation from or discussion with the other person concerning the actor's differences with the other person while the actor was carrying a weapon or possessing or transporting a weapon in violation of the unlawful carry statutes. So this is a good example here. There's a special rule that says it's not self-defense if you went over there to pick a fight, or you got a bone to pick with somebody and then you go pick it and you're carrying a weapon. You don't get to then use self-defense. Now, this is not deadly uh, force that we're talking about. This is regular force, but you can't use that. Okay. Now we're in subsection C. The use of force to resist an arrest or search is justified in Texas if, before the actor offers any resistance, the peace officer or person acting at his direction uses or attempts to use greater force than necessary to make the arrest or search. So this is like you have not resisted arrest in any way, and they body slam you straight into the concrete and crack your orbital socket. You can start resisting because they're just assaulting you at that point. This is clear police brutality. You get to resist that. Please do not hear me saying that you can resist police. This is an extraordinarily limited exception, and it's almost never going to actually work out in your favor. You're probably just going to get beat up by the police and then charged. It's extremely difficult to get this to apply, but it is here. It's worth discussing. Subsection C2, when and to the degree the actor reasonably believes the force is immediately necessary to protect himself against the peace officer or other person's use or attempted use of greater force than necessary. So you'd have to believe they were about to commit horrible police brutality against you. Then in Texas, you can resist. Subsection D, the use of deadly force is not justified under this subchapter except as provided in the other subchapters 9.32, 3.3, and 3.4. Not sure why that's necessary to discuss, but it's there. A person who has the right to be present at the location where the force is used, who has not provoked the person against whom the force is used, and who is not engaged in criminal activity at the time the force is used is not required to retreat before using force as described by this section. Okay, does everybody catch that? This is the castle law. This is saying that you don't have to run away first. if you haven't provoked anybody, if you have the right to be where you are, you're not criminally trespassing on somebody else's property, it's your property, or you're in public or somewhere where you are allowed to be where you're at, you didn't provoke them, and you don't have like an illegal possession of a firearm on you, you're not public intoxicated, not any of that, you can just stand your ground. That is the stand your ground rule, is subsection E of 9.31. Subsection F, for purposes of subsection A, in determining whether an actor described by subsection E reasonably believed that the force was necessary, a finder of fact may not consider whether the actor failed to retreat. You can't say a reasonable person would have run. You have to say, if a reasonable person had stayed, what would they have done? If they would have used force, then congratulations, you are justified under subsection E 9.31, self defense, Texas Penal Code. Whew. A lot of words there, folks, but that's probably the fastest explanation I can give for that. And I think it was a complete one. We went over every word of that statute. I hope you enjoyed what you saw. If you did, don't forget to like and subscribe, and follow us on Facebook, Twitter, all the other things. Help us out. If you have a criminal case, make sure to get a consultation from a real lawyer like me or anyone else that you trust. Thanks so much. We'll see you next time.